Hi everyone. Good afternoon. I hope you guys can hear me. My name is Botao, and today I'm going to talk about the dilemma in plant variety protection for small-scale farmers, and I will go through a case study of Bowman versus Monsanto case. But before we get started, we need to understand two major concepts in plant patent protection. That is the UPOV and the PVP. So the UPOV is International Union for the Protection of New Varieties of Plants, and they provide and develop the legal, administrative, and technical basis for international cooperation in plant variety protection. And the PVP is short for Plant Variety Protection. And in the US, the Plant Variety Protection Office, the PVPO, provides intellectual property protection for breeders of new varieties of sexually reproduced, tuber propagated, and asexually reproduced plant variated. So in short, the relationship between the UPOV and PVP is that if you're a country or organization, you join the UPOV or you enact UPOV, you can develop your own PVP law under the UPOV 1991 framework. So with that in mind, we have our case, a major case that is Bowman versus Monsanto. Bowman, he's a 75-year-old Indiana farmer who purchased a second generation seed from a grain elevator for his second planting. And it turns out the seeds is very great. So he saved the seeds from that purchase and reuse later. And the Monsanto find out that in those second generation seed, it contains their patent seeds genetic traits. So the Monsanto brings the Bowman to the circuit and to charge him for the infringement. And the district court award damages to Monsanto of 84,456 US dollar, and federal circuit and the Supreme Court affirmed that. So the question in this case is like, does a patent right for the self-replicating technology such as seeds expire after an authorized sale? And the Supreme Court decision is that no, a farmer who buys patent seeds could not reproduce them through planting and harvesting without the patent holder's permission. In this case, I really appreciate the Supreme Court's effort to protect the breeder's right, but there's another thing we need to consider is that most of the farmers in the world, in the US, are small scale. According to the Census of Agriculture, 91% American farms are small, and more than 60% of them are extremely small. Even though they don't provide the majority of the crop in the world, they are very important in farmers' innovation and food safety, nutrition security, and other stuff. So it's important. We not only have laws to protect the breeders, we also have laws to protect small-scale farmers. And so I study study the PVP law from other countries such as China, another huge agriculture country, and also Africa countries who joined the UPOV recently. So actually, the current UPOV 1991 framework have these two things to allow their members to kind of develop their own PVP law. The first is that the UPOV members can decide to allow farmers to replant seed on their own farms without authorizations of the breeder under certain circumstances. And also the 1991 Act and the 1978 Act give no definition of the words commercial and subsistence farming. So this is a place the UPOV members can play with. So in China, I study a case that's very similar to the Bowman Monsanto case, but it has exemption for small-scale farmers to reproduce and consume seeds by themselves and without the permission. They don't need the permission from the breeders. And in Chinese, it's called 自繁自用. And in the African countries, they also have exemptions for small-scale farmers to reproduce, consume, and exchange seeds within their community. And they also don't need permission from the breeders. So it's pretty relies on like the culture, the geographic and economic status those countries are in. In China and the African countries, they're mostly small-scale farmers. They don't have a lot of huge farms, so they have this kind of exemptions to protect them. So I have two suggestions to better protect our small-scale farmers. At the same time, we can also protect the breeders to give them incentive to create more innovative plants. So the first suggestion is to build a differentiated system that provides varying levels of protection. Certain types of farmers and communities could be exempt from the patent infringement, while the rest of them could have different levels of penalties according to farmers' behaviors when they're from infringement. And secondly, we need to create a better PVP education system for farmers. So instead of simply you hold a UPOV plant variant database, the authority needs more proactive approach to provide related law information. Yeah, so that is, thanks everyone. Thanks for hearing.